Hello friends, I hope you are all doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today, we will discuss the topic of Muslim Women Protection of Rights in Marriage Act 2019 with a focus on issues pertaining to the protection of Muslim women's right relating to triple talaq. Now let's start with an introduction first. Under Muslim law, marriage is a religious duty as well as a contract. It is a civil contract as one party makes an offer of marriage and the other party accepts the offer. The consideration in Muslim marriage is the dower, which the husband is required to pay to his wife. The contract of marriage under Muslim law may be dissolved by the husband, by the wife, by mutual consent of both husband and wife, and by judicial decree of the court. Under Muslim law, a marriage is dissolved either by death of the husband or wife or by divorce. After the death of the wife, the husband may remarry immediately, but the widow cannot remarry before a certain specified period called iddat. The duration of iddat is 4 months and 10 days, and if she is pregnant, until the delivery of the child. Now moving further, let's first discuss the meaning of talaq, which is divorce under Muslim law. Talaq in its original sense means repudiation or rejection under Muslim law. It means a release from the marriage tie. The talaq may be pronounced by express words or by elusive words. A Muslim husband possesses the right to pronounce talaq either by word of mouth, that is orally, or in writing. There is no specific format for effecting a talaq. Under Shia law, a husband who is able to write must repudiate his marriage by way of writing, and he must also pronounce talaq in Arabic. Talaq may be effected orally or by a written document called talaqnama. There is no special form of talaq recognized by the Sunni law. All that is necessary is that the words of talaq, as pronounced by the husband, should show an intention to dissolve the marriage. Talaq can be further divided into revocable, approved form known as talaq al-sunnah, that is in conformity with the dictates of the Prophet, or irrevocable, that is unapproved form known as talaq al-biddat, that is of innovation, therefore not in conformity with the dictates of the Prophet. Talaq al-sunnah is further divided into ihsan, the most approved, and hasan, approved, while talaq al-biddat is in the form of 3 declarations at one time, or one irrevocable declaration, which is generally in writing. Ihsan consists of one single pronouncement made during the wife's tuhar, followed by abstinence from sexual intercourse for a period of 3 tuhars. Hasan consists of 3 pronouncements made during 3 successive tuhars at the time when no intercourse has taken place during that period of purity. Talaq al-biddat, where 3 pronouncements are made in a single tuhar, which is instant and irrevocable. This comes under the contention as triple talaq, which has been invalidated by the Instant Act. This practice is neither recognized by the Quran nor by the Prophet Muhammad. This is the disapproved form of talaq. It is an irregular mode of talaq introduced in order to escape the strictness of the law. The rest of the forms are non-prevalent forms of divorce and hence of little practical importance. Ila, that is vow of continence. In this, the husband swears not to have intercourse with the wife and abstains for 4 months or more. In zihar, that is injurious assimilation, here the husband compares his wife to members of his family within prohibited degrees. Now moving further, let's discuss the case of Shaira Bano versus Union of India, which was decided in 2017 and which has led to the enactment of Muslim Women Protection of Rights in Marriage Act 2019. In this case, it was held that triple talaq was illegal, arbitrary and violative of fundamental rights. The apex court also held that the Muslim personal law, that is Shariat Application 1937, insofar as it seeks to recognize and enforce triple talaq within the meaning of the expression laws in force under Article 13, Clause 2 of the Indian Constitution, shall be struck down as being void to the extent that it recognizes and enforces triple talaq. The court further held 3 things in this regard. Firstly, triple talaq is governed by Shariat. The specific grounds and procedures for talaq have not been codified in the Act. Secondly, triple talaq is against the basic tenets of the Holy Quran, which violates Sharia. And lastly, triple talaq forms no part of Article 25, Clause 1 of the Constitution of India. In this case, the court directed the central government to make a law to abolish the practice of triple talaq in India. After this, the Muslim Women Protection of Rights on Marriage Act 2019 regarding the abolition of triple talaq was passed by both houses of parliament in 2019. The act criminalizes instant triple talaq amongst Muslims and attracts an imprisonment of 3 years for the husband. The act has retrospective effect as of September 19, 2018. The act has declared the pronouncement of triple talaq by husband as void, illegal and unconstitutional. And it also has laid down that any husband indulging in such practice would be liable to be punished with imprisonment up to 3 years. The Act also provides that the divorced woman will receive maintenance allowance or compensation from her husband for herself and for her minor children. Under the Act, talaq means talaq-e-biddat or any other similar form of talaq having the effect of instantaneous and irrevocable divorce pronounced by a Muslim husband as defined under Section 2 Clause C. Under the Act, any pronouncement of talaq by a Muslim husband upon his wife by words either spoken or written in electronic form or in any other manner whatsoever shall be void and illegal. Said offence held can only be committed by a Muslim husband. Mother of the husband who pronounced triple talaq cannot therefore be made liable for the same. Under Section 4 of the Act, any Muslim husband who pronounces talaq upon his wife shall be punished with imprisonment for a term that may extend to 3 years and shall also be liable to a fine. Moving further, let's now understand the judicial interpretation of triple talaq in India. The attitude of the judiciary towards the practice of instant triple talaq has always been critical. various High Court judgments prior to the watershed judgment of Shaira Bano versus Union of India gave different interpretations about the practice of instant triple talaq. While some held the practice to be bad in theology but good in law, others held that Muslim law does not, in fact, allow an instantaneous and irrevocable talaq without any attempts at reconciliation in between the pronouncements, as decided in the case of Ziauddin Ahmad versus Anwara Begum, 1981. According to the Quranic injunction, triple talaq must be on reasonable grounds, and there must be intermittent mediation facilitated by two mediators, one from each side of the family, if need be. The practice has been declared unacceptable by the apex court in number of cases too. However, it was struck down conclusively by the court in the case of Shaira Bano in August 2017. Friends, moving further, let's now discuss the status of women under the Act. Section 3 declares that the pronouncement of talaq by a Muslim husband upon his wife by words either spoken or written, or in electronic form, or in any other manner whatsoever, shall be void and illegal. Where a Muslim marriage is treated as a contract, plain and simple, such a declaration by law would have been enough to address a unilateral breach of contract by the husband. However, the problem isn't that simple. Muslim marriage, even if a contract, has a sacrosanct standing in society and is treated as such. The practice of triple talaq has been prevalent and accepted in Muslim society for centuries and is deeply ingrained in their thinking. Thus, just a declaration of it being void by law doesn't change the circumstances immediately. A woman who has internalized the idea of divorce by triple pronouncement may think it haram to live with her husband, despite it not being recognized as divorce by the law. The society as a whole may still continue to treat instant triple talaq as valid. For this reason, it is generally argued that a reform in personal laws must come from within the religious community rather than the law imposing it from outside. So, as observed in the case of Harvinder Kaur versus Harminder Singh Chaudhary by the Delhi High Court, introducing constitutional law in a matrimonial home is like introducing a bull in a china shop. The law may even be said to have muddled things further, as the status of women would be in a limbo, where on the one hand society and she herself may deem her divorced, but the law would not, hence making it impossible to enforce her rights as a divorced woman through legal mechanisms. It has also been argued that the Act might as well encourage husbands to willfully abandon their wives rather than pronounce triple talaq. Because of the muddy status of the disempowered woman, her blood relatives may also be reluctant to take her back since she cannot marry again. It is not far off to argue that the laws not being in sync with the societal expectations would lead to the destitution of Muslim womanhood, whereas protection of whose rights was the sole objective of this legislation. Friends, further, let us now discuss the provisions for maintenance and custody of the wife and children under the Act. Section 5 of the Act ensures that a woman on whom triple talaq has been pronounced will be entitled to a subsistence allowance from her husband for herself and dependent children, as determined by the magistrate. It is important to note the language of the section. It ensures only a subsistence allowance and not maintenance, as under other laws pertaining to women's right. Maintenance implies the amount of money required to continue living according to a person's standing in society, while subsistence allowance is the bare minimum amount required to meet the expenses of day-to-day living. However, the provision is without prejudice to the generality of provisions contained in any other law, which means the woman is still free to initiate proceedings for maintenance under Section 125 of the CRPC 1973. A married Muslim woman is also entitled to maintenance known as nafqa, irrespective of whether she can maintain herself or not. Hence, it is unclear what the purpose of the given section is in the form of a subsistence allowance. Another question that arises is due to the aspect of criminalization under this Act. Given that the Act criminalizes the pronouncement of triple talaq and in the same breath entitles a woman to subsistence allowance in case where the husband is reported and sentenced to imprisonment, from where does the proposed allowance come from then? Section 6 of the Act provides that a married Muslim woman shall be entitled to custody of her minor children in the event of the pronouncement of talaq by her husband. Thus, she is entitled to such custody as a matter of law. The first question that arises is about the need for provision for child custody when the marriage is still subsisting and no divorce has taken place. Additionally, making such a provision mandatory is unreasonable. In other statutes governing divorce, the custody of children is left for the determination by the courts. Other factors such as the best interest of the children are given paramount importance. This provision provides for no exceptions and no proper criteria to determine the custody of the children. There might be scenarios where the mother herself is not financially or mentally fit to take care of the child, or the child does not wish to live with the mother, etc. Such exceptional situations have not been taken into account while drafting this provision. Moving further, let's discuss the criminalization of the offense of talaq. Section 4 of the Act lays down the punishment for the pronouncement of triple talaq by the husband, that is imprisonment up to 3 years and a fine. This point has mainly been the bone of contention in this Act. Human conduct is regulated by various means, while civil means are enough to regulate most of the human behavior. Sometimes deterrence is required where civil law fails to regulate the behavior. That shows a serious departure from norms and is capable of infringing on the lives of other citizens. The primary problem associated with criminalizing the pronouncement of instant triple talaq is that by doing so, the legislature is imposing penal and criminal consequences for a civil wrong. Marriage under Islam is a contract. The breach of a contract should not ideally lead to the attraction of a criminal sanction. As far as criminalization is concerned, the state should adopt a minimalistic approach. Curtailing the liberty of a person should be the last resort. Criminal law is only one of many mechanisms to censure and prevent deviant conduct. Only the most serious violations should attract the law's most coercive and condemnatory technique, that is criminalization. The state must adopt a minimalistic approach to the criminalization of offences because a stronger justification is required where an offence is made punishable with imprisonment. Over the course of time, many shortcomings have been found in the Act. Let us now discuss them one by one. The practice of instant triple talaq can be checked by civil means as well. Criminalization can be the last resort when civil remedies have been exhausted. The minimalistic approach advocates for leaving out the purview of criminal sanction, such conducts where prohibition is unlikely to be effective or where it would cause greater social harm than not penalizing it. In other words, punishing a person should not become counterproductive. In the case of criminalization of instant triple talaq, this is very likely to happen. The Act aims to prohibit instant triple talaq and protect the rights of married Muslim women. It is pertinent to note that if the man is imprisoned, it is very likely that all his family members, including his wife, will become destitute. Additionally, the act of pronouncement has already been declared void by Section 3 of the Act. Thus, such a pronouncement would have no consequences at all and would have no effect on the marriage. The marriage would still exist in the eyes of law. However, it is a bit optimistic to expect that the marriage will not suffer. There is a possibility that if the husband is imprisoned, it will lead to irreconcilable differences amongst the couple. The husband might very well divorce his wife by following the proper Quranic procedure once he is released. Also, such imprisonment would lead to unfair denial of conjugal rights to the Muslim married couple. The fear of such adverse consequences would discourage women from reporting such incidents. This would mean that there would be little deterrent effect from such a provision. Thus, the woman is left with no recourse at all. Since the offence is cognizable, the police officers have the liberty to make an arrest without any preliminary investigation. The woman would have little say in the procedure. Additionally, the prescribed punishment is not proportionate to the gravity of the wrong. The foundation of every justifiable criminal sentence is the requirement of the principle of just deserts. The punishment of 3 years has been prescribed for many graver offences under the Indian Penal Code, which includes sedition, promoting enmity between classes of people, rioting, armed with deadly weapons, etc. Imposing such a punishment for inconsequential act does not seem justified. So, to conclude with all its pros and cons, this act is still a bundle of contradictions and procedurally inconsistent. It is a case of 2 steps forward and 1 step back, as its provisions lay down a paradigm without any backward or forward roadmap. It surely is a hurried piece of legislation, passed with much theatrics, amidst a lot of hullaboos on paternalistic morals and not enough substance. The crux of the whole debate has been lost in the clamour of right-wing and left-wing politics. It is unsubstantiated and myopic, but at least a small step forward in the direction of women's emancipation. In the end, the law is only as good as the institutions that implement it. And for now, we are witnessing more violations than compliance with their provisions. It is observed that entrenched patriarchy is a great stumbling block that repeatedly comes in the way of implementation of even the best designed legislations. Patriarchy infects not only most of our citizens, but also institutions like the government, administration and judiciary, which are invested with the responsibility of implementing these and other laws. While there is a greater rise in the incidence of women-centric offences, laws dealing with them are being whittled down in some cases or are simply not being implemented in others. The fact of the matter is that we cannot build a gender-just system without dismantling the patriarchy entrenched within our society. What is of utmost importance is the strengthening and prioritizing of social reform movements that challenge orthodoxy and patriarchy. So with this we come to the end of today's lecture. Thank you very much.